Good afternoon and welcome everyone. Thank you so much for joining our webinar on the new short-term rental regulations and their impact on condominium communities. My name is Lauretta Enders and I'm the principal broker with Emerald Management and Realty, and I'll be your host for this session. For housekeeping, I'd like to start off with a land acknowledgement as we acknowledge that we are residing on Treaty 7 territory, which includes the traditional territories of the Blackfoot, the Tsuut'ina Nation, and the Stoney Nakoda, and home of the Métis Nation of Alberta Region 3. The land on which I work from, where the Bow River meets the Elbow, and is what we now know as the City of Calgary. We honor and respect the importance of land to the traditional territory and are committed to learning about our shared history and acting according to build a better future for all. So just a few housekeeping items before we get started. Your microphone is on mute and will be throughout the presentation to avoid any background noise. We encourage you to ask questions by typing them into the Q&A section at the beginning at any time during the webinar, as we've a dedicated Q&A session at the end where our panelists will address many of your questions as possible within the time frame. So to get this started, today we are very fortunate to have three distinguished panelists with us. We have Chris Lowe from BFL Canada, who specializes in insurance solutions for property management. We also have Kayla, also from BFL Canada, bringing extensive experience in risk management, and Dionne from SVR Lawyers, an expert in real estate law with a focus on condominiums. Each will share their insights on how the new short-term rental regulations will affect your condominium operations and compliance. So I'll pass this on to Chris and share our screen so we can dive into our discussion. Thank you, Chris. We'll pass it off to you.
Thank you very much, Lauretta. Good afternoon, everyone. My name is Chris Lowe, and I'm your client executive. I'm a client executive who represents BFL Canada as your insurance broker, and we're about to basically jump into a little bit of content that we had designed specifically for you here today to talk a little bit about the insurance, and then afterwards, there's going to be some content from Dionne talking about the legal landscape. Next slide. So just a bit of general housekeeping within the information that we're about to present here today. We had just gone through the table of contents to basically confirm all of the information that Lauretta had sent. Please save all of your questions for the chat, and then we will address them as we come along to the conclusion of the presentation. So here we're going to start talking about the Condominium Property Act and insurance coverage. So the first thing that we're going to be talking about is the fact that when we're looking at it from a corporation's insurance perspective, all corporations in the province of Alberta are governed by the Condominium Property Act. The Condominium Property Act is a very large and expansive document, and specifically what we're going to talk about here today is one specific article, which is the insurance section found on section 47, article 6A. So this specific section will basically talk about how the corporation's insurance policy is supposed to respond. In this particular case, the corporation's insurance is always primary. So what that basically states is Article 6A notates that the insurance placed by the corporation is always deemed as first loss insurance. The reason why we're starting the process off and the presentation in this manner to talk about the Condominium Property Act and the insurance section of the Condominium Property Act is because whenever the corporation has any types of losses, it's the corporation's insurance that has to respond first. Next slide. This second slide is designed to be complementary to the first slide because it's going to be talking a bit about the regulations and insurance. So we just talked about the corporation's insurance responding first in all instances. Today, what we're going to be talking about regarding the regulations goes all the way back to January 1st of 2020, talking about the regulation change where the corporation was afforded the power to assess their deductible up to a maximum of $50,000 to a unit owner in the event that a loss happens within their unit. So specifically, it could happen in a couple of different ways. I'll explain. I did just mention that the maximum, the ceiling that the corporation can assess back is 50,000 or whatever the corresponding deductible is. So bringing it together, we just basically talked about the initial go. We're talking about the Condominium Property Act and how the corporation's insurance is always first loss respondent, meaning that they're always primary. And the last slide, the one that we're talking about here today, is talking about the fact that in January 1st of 2020, the regulations improved for corporations, giving them the opportunity to assess their deductible back to a maximum of 50,000 to a unit owner. Next slide. So this slide, we're going to be talking about, and here's the header, more traffic, more opportunities for loss. So because we're talking in regards to short-term rentals, which is a very hot topic at the moment and has been for a number of years, and we're talking about Airbnbs, we've basically now started this slide to really determine the fact that if you do have short-term rentals and if you do have Airbnbs, there's always going to be the opportunity for, a lot of folks to be coming into these units. It's not one of those things where you can quantify in an annualized basis how many folks are going to be coming into the unit. I mean, hopefully the unit owner who basically, is having these specific units for Airbnbs and short-term rentals, they track them. But, Calgary is a very popular city, especially in the summertime. And there's always the opportunity for folks to basically come in and out of units that are designated for Airbnbs and short-term rentals. One of the main communications that we really wanted to put out on this specific slide is the fact it is prudent for the corporation and also the unit owner who owns the unit that's going to be used, for these operations to ensure that there's a general awareness to mitigate any types of claims. Because the main thing is that when we looked at the first slide that we just presented on, the corporation's insurance is always primary. And we did talk a little bit about the fact that the regulations were improved for an assessment component to assess the corporation's deductible, to a unit owner in the event that, the damage stems from their unit. So this slide is really, here to generate a little bit of awareness to basically say, if this is an operation, because it is super popular, it's been popular now for some years, a general awareness needs to be had to mitigate any losses that might occur. Next slide. So in this particular slide here, we're going to be talking about insurance claims and how they affect the corporation's insurance cost. I mean, most folks, whenever, they purchase insurance, there is always an opportunity that you're going to come into a scenario where there is a claim. In this specific landscape, we're talking about corporations insurance, and we're talking about if and when claims occur, what are the steps and how they are identified by the insurance companies. So when claims occur, they are basically to generate what is known as a loss history. This loss history is a document that ourselves or myself as a broker, we will definitely have to take a look at every single year to see, what kind of activity that has happened within any of the corporations that we're renewing at that point. So the loss history, generally speaking, is usually done over the course of about 5 years, meaning any losses that occur within a 5-year period will basically be found on the loss history. And the insurance company or carriers are going to review that loss history every year to basically take a look to see what exposure that the corporation actually has in the face of the insurance that they're about to deploy for them. So in this particular case, we're going to be talking about the two elements. There's a couple of elements that the insurance companies will look for, but we just actually wanted to demystify two of the most prominent. The insurer will look at frequency. So frequency is basically calculated by taking a look at an insurance loss history and understanding what activity would happen in any one given base year. So the word frequency is exactly what, it sounds like what they're looking for. Frequency will basically denote how many occurrences in any one given base year, may occur that may give rise to a loss. So when you look at it, one of the items that I wanted to communicate to all of our participants was the fact that if you have multiple, types of incidents, multiple claims, that happen within any one year, and it does impose frequency to the insurer, what it's directly telling the insurer, and I'll use an example. Let's just say it's 2025 and you're a corporation and we're looking at it in September and the end of the year is upon us, the renewals in December. If there's been about 3 or 4 different, circumstances that gave rise to a loss, that will definitely constitute as frequency. So the way that the insurance company is going to look at that is there are not risk management protocols that are being followed to minimize these losses. And what will happen is that the next area that we're going to be talking about that the insurance companies will look for is severity. And usually, if frequency issues are left unchecked, it gives rise to severity issues. So we're going to jump into the severity side of things. Severity is exactly what it sounds like. I mean, for something to be severe, it means it's going to be very pronounced, potentially very large. These are the bigger type losses. And what will happen is usually, if frequency issues are left unchecked, if risk management issues are not basically, taken into consideration because there isn't a general awareness of how to mitigate losses, it will give rise for opportunities for bigger losses to basically come to fruition in the future, which are known as severity losses. So upon the assessment of the report and the losses, this is what the insurance company will use at the end of the term. So when we're coming into the renewal side to determine the rating for the new policy, the upcoming policy term, and also the deductible. So the main component here, just to kind of stay within the general theme of talking, from a factor of where we started in the presentation process, is the fact that at this point in time, it is definitely very prudent for all to be very aware of the opportunities for loss to ensue and to control those losses before they happen to control cost. Next slide. So in this particular slide, we're going to jump into ways that a condominium corporation's insurance policy may respond. So when you take a look at the condominium's insurance policy, our duty as a broker for BFL is to design something for the corporation to ensure that there's an adequate risk transference vehicle to transfer the risk of a loss over to an insurance policy. So when you look at these four lines of coverage, these are just for example purposes, not to be exhaustive. When you take a look at an insurance policy, especially a BFL-based insurance policy, you will notice that there are multiple lines of coverage, over and above the four that you see here. The reason why we've put these four here is to just basically generate a general awareness, and it basically showcases the different needs for the different lines of coverage that we're about to talk about. So to dive into the examples for the lines of coverage, the first one we're going to be talking about here is property insurance. So property insurance is exactly what it sounds like. Property insurance is designed to cover all of the corporation's property. So when you look at it, a lot of you folks will notice that if you've retained the services for property management from Emerald and BFL is your insurance broker, upon the renewal of the insurance program, we're going to be asking for things like the appraisal. The appraisal is what's going to dictate what the total value of the structures are. And then once we receive it, then we provide it to the insurance company to ensure that the corporation's assets are all covered. So the property insurance coverage can also be modified to basically speak to the bylaw section, or at least the bylaws that are provided to us upon renewal. So specifically speaking, if the bylaws specifically state that the onus is on the corporation to basically ensure the improvements and or betterments, then that will be covered within the property insurance section as well. One of the other things that will be covered under the property insurance section for the corporation's policy are any contents, that may be held in common areas, any artwork, any furniture, if there's, a couple couches and whatnot, that are held in the lobby. So those are also held within the property section of the coverage. So we're going to move forward into the commercial general liability. And what you'll notice within the next two sections, because we have commercial general liability and just underneath there's another liability coverage, each and every different coverage is designed for a specific trigger. So commercial general liability, I'm going to tell you what the triggers are. The triggers are, from a corporation perspective, is for premises liability because the corporation has a duty to basically ensure that all of their surroundings, in and around wherever the buildings are basically held harmless from any opportunities where a third party can encounter any kind of loss. So a commercial general liability policy will have two deductibles, and the two deductibles are as such. There's bodily injury and or property damage. And for the corporation's policy, if a third party purports that due to the negligence of the corporation that they sustained either bodily injury or property damage, the corporation has a defense under the commercial general liability policy to ensure that they're taken care of. The next one we're going to take a look at, and I know that there's probably going to be a number of directors and or officers that are joining this call. and your ears are perking up, and as it should, because the directors and our officers liability policy is designed to cover off the exposure of basically the directors and or officers coming together as a volunteer group and making decisions on behalf of the corporation. So basically, when the boards of directors make any decisions, if these decisions specifically trigger any types of losses that may affect either an individual or a body of individuals, and a suit basically, is put forth, to the board of directors, the directors and officers liability will provide a defense, and it will ensure that the board of directors does not have to indemnify with their own personal assets. We all know that I've sat on a board of directors for where I live as well too, and it is a thankless job sometimes. But it's nice that we have some really great folks come into the table to be able to make sure that everything is taken care of for where we live. The next and the last one on this list here, which is coming to the conclusion before we get involved with talking about Kyla's slide, is the legal expense coverage. So the legal expense coverage is an interesting line of coverage in my opinion, because it will give the corporation the access to a lawyer. And I mean, when you take a look at it, there are other policies that will provide a defense, like the liability and the directors and officers liability. But this specific line of coverage is designed with two opportunities where you can actually leverage it for the corporation's purposes. And we're going to talk a little bit about it here today. So the first one here is that the corporation can actually trigger unlimited legal advice. And I can tell you, if you have a scenario where you get in touch with one of the great property managers from Emerald, and you have a little bit of a scenario and you want to run it by them, you're going to be getting in front of myself and Kyla in short order, and we're basically going to be getting in front of the legal expense coverage if it makes sense. So I'm going to talk a bit about the parameters. The unlimited legal advice is exactly what it sounds like. It can be triggered at any time throughout the course of the policy period, and it is unlimited. So what it's to be generally used for, it has to be used for board business only, and it cannot be used for things that would be very expansive. And I'll give you a quick example. You can't call them and ask them to basically rewrite the bylaws, because that's definitely a pretty big endeavor. You can use it for just general questions. And when you get in front of them, you can basically either give them a call as part of a 1-800 number, or you could basically send them an email. What I would probably recommend, Kyle and I have done this many times in the past. You don't have to do it this way, but, to keep everything in order, you could basically just send an email, and then you have, just a trail, and then you can follow up with them, so on and so forth. The next and last part of this section, talking about the second way that you can trigger the legal expense coverage, is by basically getting a legal, or at least legal representation of the territory. If there is a scenario where the corporation needs to have legal representation, they can actually trigger that through the legal expense coverage, where it will basically assign a lawyer within the province of Alberta, specifically because we're here in Calgary. You're able to actually have a lawyer represent the corporation if that's the need. So this is the end and the conclusion of this slide. We can move to the next one, where we're going to talk a bit about the claims with Kayla.
Perfect, thanks, Chris. I'm going to review a claim scenario that we often see here at BFL in regards to Airbnbs, and then how also your policy may respond. So a unit owner is going to rent out his unit on Airbnb, and then the occupant has a party inviting many individuals to his unit, and then that invitee falls down the main entrance stairs while leaving the building, injuring themselves. In turn, that invitee then sues the unit owner, the host being Airbnb, and then also the corporation. The corporation then in turn is going to notify BFL, and at that time, we're going to review that statement of claim and see what those allegations are. The allegations on the statement of claim are directly going to correspond with which policy we're going to notify. We might notify all three of them, it's just depending on what those allegations are. So lines of coverage that could be notified is going to be your commercial general liability. This is going to be primary to respond to the injury itself. And then AREG legal expense and directors and officers. All three of these policies do have strict timelines for reporting. So it is important that you notify BFL as soon as you are notified of that statement of claim, just so that we can meet those guidelines and make sure that we can get them reviewed as soon as possible. You can do the next slide.
Excuse me. Thank you very much, Kyla. So This last and final slide towards the insurance section that we have been presenting here today are steps to basically just generate a little bit of awareness, because we've talked a bit about a couple of different things. We started off our presentation talking about the Condominium Property Act and the corporation being primary, responding coverage in the event of a loss. Then we jumped forward to the regulations, which basically talked a bit about the fact that in January 1st of 2020, the corporation was afforded the power to assess their portion of their deductible up to a maximum of $50,000 in the event that there is a loss that occurs in one of the units. Then we talked about more traffic and more opportunities for loss, because the topic at hand that we've been talking about here today in this presentation surrounds a very popular aspect, which concerns short-term rentals and Airbnbs. Yeah, then we also talked about the lines of coverage. We only talked a bit about the four lines of coverage. Then there was a claim situation, and we're ending off here in steps on how to minimize risk, because at the end of the day, the main component when you're looking at it from a risk perspective is to ensure that there's awareness. There has to be a commitment to learning risk mitigation strategies to enhance safety, communication to all unit owners to all that strategy, because I mean, when you look at it, it is basically up to everyone, especially if you're going to be living in a condominium, townhouse, low-rise apartment style, or even a high rise. Everybody has to have a commitment towards ensuring that the location is safe. So how BFL is basically able to help you to do this, we've basically partnered and asked Lauretta to have the BFL home maintenance and risk prevention tips provided to all the participants here on this call here today. And we always kind of joke, and I know it's getting a bit long in the tooth, but for those that know me, if I don't joke about it now, you guys will probably think there's something wrong with me. So if you guys have trouble falling asleep and you want some light to medium reading, the home maintenance, you could keep it on your bedside table and everything will be great. And I promise, not unlike some of the insurance policies that we administer, my picture is not on there, so you won't get a fright. So I just wanted to say thank you very much to all of the participants here today. I know that definitely everybody's quite busy, and the fact that you guys are all participating on this call here today is definitely a sign of your commitment to awareness and keeping your location and surroundings safe. And if you have any questions or any concerns that either Kayla and myself can actually jump in and help, please get in touch with Lauretta. Next slide.
Thank you. I guess I'll take it from here, Chris. And my part is the legal landscape, which is very interesting to me, and hopefully it'll be interesting to you as well. And I'll just jump right in because we're about 2:22. But really, there's two levels of authority that we're looking at when we're thinking about how to restrict or permit short-term rentals and condominiums. And that's number one, the condo bylaws and what the condo can enact and enforce via their bylaws and their rules and their regulations. And then there's the municipal bylaws and what the municipality can do. And of course, that it applies more broadly, not just to condominiums, but to single family homes and anyone, rental buildings, to anyone who's really operating a short-term rental in Calgary. So the first question that we sort of start with is, can condos enact bylaws to prevent people from using their units as a short-term rental? And 10 years ago, this was actually, as of 2019, this was an undecided question. The big thing in the Condominium Property Act is this section here, 32 sub 5, that says no bylaw operates to prohibit or restrict the devolution or any transfer, lease, mortgage, or other dealing with them, or to destroy or modify any easement implied by the act. Big important part of that is the first part, no bylaw operates to prohibit or restrict a lease. And so many lawyers had interpreted that as that any bylaws restricting leases were simply invalid. And I'll go to the next slide. In 2015, the court had an opportunity to evaluate 32.5. That was a Canmore project. That was different than an Airbnb, but this was before Airbnb was widely prevalent. And the issue was that the bylaws required all owners to participate in a rental pool if they wanted to rent, and the Scots wanted to rent on their own. And they said section 32.5 of the Condominium Property Act applied in their favor, and they didn't have to participate in this rental pool. The court agreed with them. And I won't go through the first two paragraphs there, but the last bullet point is the most important. The right to alienate one's unit includes how one will rent it out. So that's what the court, as of 2015, said. 32(5) does not allow condominiums to enact bylaws that restrict renting. Now, fast forward to 2019 in the next slide. Who's my slide person?
I can see not, can you not interim injunction?
There we go. Perfect. Thank
Okay.
you.
You're welcome.
The next one, and these are really the critical cases in Alberta, and actually they've been applied across the country, are the Cusio cases. And the Cusio, there's Cusio number 1, which was a interim injunction, which is basically a temporary injunction while the actual final application got heard. The second one being the final determination. So Cusio was a downtown Edmonton condo, and by 2019, Airbnb was in full force and effect and was a problem in a lot of condominiums. This one happened to be next to Rogers Place, and so it was a great Airbnb location, and we had 4 different owners all renting Airbnbs. These Airbnbs were troublesome for the condo. They had noise issues and all sorts of complaints from the owners, and so they took action to restrict the Airbnbs. Their bylaws had 2 provisions which are actually really common in bylaws across the board. The first one is a single family use or one family residence provision. So it says that a condo unit can only be used by one family, no guests, boarders, or roomers. The second one that is very common is it states that no unit can be used in whole or in part for any commercial or professional purpose involving the attendance of the public at such unit. Next slide. And the court looked at these, oh, sorry, back one. The court had a look at these ones, these 2 bylaws and the operation of Airbnbs generally, and they agreed these 2 bylaws definitely do prohibit Airbnbs. A single family use cannot be interpreted to include operation of a hotel-like business with units being offered to complete strangers on the internet on a repeated basis for durations as short as a single night. It's just incompatible with the concepts of check-in and check-out times, cancellation policies, security deposit, cleaning fees, et cetera, et cetera. With the no commercial use, the reservation systems, availability calendars, deposit and cancellation policies, acceptance of credit card payments, and arrangement of service and cleaning fees, those were all indicative of a commercial as opposed to a residential use. Next slide, please. And then the court said, okay, well, we know these 2 bylaws do prohibit commercial Airbnbs, but how do we get around that Condominium Property Act provision that states that bylaws cannot prevent people from renting their units? How the court got around it is they drew a line between a lease and a license. So a lease is a non-exclusive right to use a property. A license does not create an interest in land. Sorry, that should say a license is a non-exclusive use to use a property. It really comes down to a question of law rather than the labels the parties use. So you can't enter into a 3-day rental with somebody and try to call it a lease when you're using these hotel-like bookings and it has all the other indicia of a true Airbnb unit. And then the killer for everybody was that the Airbnb agreement itself, so when you rent through Airbnb, that agreement expressly refers to a license. So it says you are licensing this unit from this owner, not that you are leasing it. You can probably skip down to the next one. So in the final injunction, like I said, number 1 was temporary, number 2 was final. This went to Justice Belzel. Interestingly, the very first sentence of the case, he says, We're just dealing with the issue of where there is no written lease in place, because with the Airbnbs, they didn't have written leases. They were just booking through the online portal. So we're not talking about a situation where there is no lease in place. But other than that, he substantially agreed with the first justice, and basically short-term occupancy through platforms like Airbnb, where no lease is entered into, are the functional equivalent of a hotel stay. They're licenses, not leases. So section 32.5 does not apply, and they violated the no commercial use bylaw and the single family only use bylaw. Next slide. So what Justice Belza left open was, okay, well, what happens if you have a written lease in place for your Airbnb? So what happens if you have a 2-week stay and instead of using the Airbnb platform, you write a separate standalone lease? Well, we see this in what I called Cusio number 3, but it's actually the same condo versus a person named Porter. So this was the exact same condo, the same guy in the first 2 Cusio cases doing the same thing, but now he has a written lease with his tenants, or she. And unfortunately, or fortunately for them, they pulled the same judge. That was Justice Belzel. Ultimately, Justice Belzel said, look, you can't call something what it's not. You can't call an orange an apple, and now it's an apple. If it walks like a duck, quacks like a duck, it's a duck. This particular lease also had a provision, I've put it up there. It didn't have a true month-to-month renewal provision. They altered it so that the tenant could, I guess, cancel the month-to-month lease on 5 days' notice. And interesting, the lease also didn't have a fixed rental amount. So there was no actual rental amount. It could vary from month to month. Justice Belzel looked at this particular agreement and said, look, in substance, this agreement is not a lease. This is just a license. It's intended for short-term occupancy, which sort of puts into question some of the, I guess, executive rentals where people operate them from month to month. Now that's all where we are at with the condo bylaw stuff. Ultimately, when it comes down to condo bylaws, can a condo prohibit Airbnbs? Yes, because they are a license, not a lease. Interestingly, a lot of condo bylaws already have the no commercial use or no single family use bylaw. So by default, there's an argument that Airbnbs are supposed to be prohibited in all of those condos. But there is a big exception. If a condo has been, or if a developer potentially has been promising people that they can operate an Airbnb, those condos may be stuck continuing to allow Airbnbs. Again, this is really fact specific, but I just want to make sure we don't broad brush that all condos with those bylaws are completely prohibiting Airbnbs now. So moving on to the City of Calgary requirements, down here are the current STR license requirements. So if they define a short-term rental as anything under 30 consecutive days, when you sign, fill out the application that you send into the City of Calgary, you have to show proof of ownership with a title search or something else provided to the city. And this is the big one. This was great when it got in place for condo boards. Written proof from the board that the short-term rental is permitted. So currently, if you pull up the application, there is a section where you are supposed to send in a letter of authorization or something similar, confirming that the condo board has allowed you to operate this short-term rental. Most people who are operating in short-term rentals in condominiums do not have this. You also have to provide proof of insurance indicating that the location is insured for home sharing or short-term rentals. Really important point on insurance. The Airbnb insurance that's available through the website, that is not good enough for the City of Calgary licensing requirement. They want to see an insurance certificate confirming you have liability, and it has to be through one of the providers that are permitted to operate in Alberta. There's a link when you go to the application, it takes you to that list. There does have to be a license inspector review, and you also have to submit a fire safety plan and complete annual fire inspections through the City of Calgary. And of course, it's a business license, so you do have to pay a fee. Most condominiums would operate under the lower fee because I think it's $5 4+ or 5+ rooms bumps you into the higher category. Now, as of April 1st, 2025, well, in December, the city passed these, but these are going to come into effect April 1st, 2025. We're now going to have two different license types, your primary residence and your non-primary residence. So if the vacancy rate falls in Calgary to below 2.5%, no more license applications will be permitted for non-primary residences. So if you have a rental property, you're operating it as a short-term Airbnb, valid or not, you're not going to be able to get that if the vacancy rate is really low. Currently, and Lauretta, I might get you to talk to this, that we are not near 2.5%, or we're a little bit close to it, but we haven't hit that mark. They also have expanded the definition. So now instead of being 30 days, the new definition is the short-term rental is up to 180 days. So it means the business of providing temporary accommodation for compensation in a dwelling unit or portion of a dwelling unit for periods of up to 180 consecutive days by advertising or otherwise listing with a short-term rental company. That will catch a lot of the people who advertise or use their units as an executive rental. The digital STR platform, so there's a variety of them now. There's the big Airbnb, but there's also a lot of smaller operators. They will now have to pay a $3,000 annual fee. And there's an enforcement piece to this. They have to provide a monthly list of all short-term rentals to the city. The city can ask the rentals be removed, and there's a $1,000, like removed from the website. And there's a $1,000 fine to the STR operators if they do not comply with the city's requests. I think this is going to apply to Airbnb, but we have yet to see how this is going to operate. Licenses can't be issued to affordable housing homes, which makes sense. One really bad thing for condos, they have removed the condo board consent. I looked through all of the city documents putting in place these changes. I could not find any rationale as to why they removed condo board consent. Lastly, I just put this on there. It probably should be on the next slide. There could be some GST issues. This isn't really related to the STR licensing requirement, but we could talk about GST in the next part. So again, this is what a lot of bylaws in Calgary say. An owner shall not use his unit or any part thereof for any commercial or professional or other business purpose, or for a purpose involving the attendance of the public at such unit, unless such use constitutes an authorized, permitted, or discretionary use or an approved home occupation as defined in the relevant City of Calgary bylaw. The question I have had once in a while is, if the owner now has a license, is that considered an authorized, permitted, or discretionary use? In my view, I don't think it is, because I think an authorized, permitted, or discretionary use was always intended to apply to the land use bylaw, not to business bylaws, and it's still not going to be an authorized, permitted, or discretionary use under land use bylaws. But this is not something that has been decided by the courts, and it is potentially a bit of a question mark. Executive rentals, again, I touched on that a little bit. It sounds like they are going to be caught by the new City of Calgary requirements, and you will need a license to operate them if they are permitted by the condominium bylaws. Subleases are a problem sometimes for us, because sometimes you'll have one person renting out the unit from the owner, and unbeknownst to the owner, that person will then sublease the unit as a short-term rental and make a bunch of money off of it. That person still needs to have a license with the City of Calgary, the sublessor, the person doing the subleases, and that use still may be prohibited by the condominium bylaws. And ultimately, regardless of whether the tenant is doing it or the owner is doing it, as owner, if your bylaws prohibit short-term rental use and you're going ahead and doing that, as an owner, you're going to be the one who's responsible at the end of the day. Catching an owner doing an illegal Airbnb could probably be a topic entirely to itself. We have some of these in some condos downtown. I liken it to playing whack-a-mole because you'll get one and then another one will pop up. And then you get another one and another one will pop up. Or you think you caught one and then 2 months down the road, they might pop up again. It can be difficult. Evidence is key. Keep an eye on where lock boxes are being placed. If lock boxes are being placed, they shouldn't be being placed on condo property, but we have had instances where they're placed on neighboring property and people pick up the keys from the neighbor and then go into the unit that way. They can be tough. If you have concierge monitoring on a daily basis, that does help. And if somebody is looking at Airbnb and can recognize the suite, like a board member, that might be able to be used as well. Sometimes we might be able to demand that the owner or the person operating the Airbnb produce the Airbnb listing history so that we can confirm whether or not the Airbnb has been used as a short term or as a long term. Sometimes owners will say that they're just using the Airbnb as a kind of an advertising platform, but they're actually entering into long-term leases. What if you've been using or allowing Airbnbs, but your bylaws restrict them? That can be a hairy situation, and you might want to talk to legal counsel about that one. There is precedent to say if you've been allowing them, that you might have to, well, it's just like any bylaw. If you don't enforce your bylaws and you're allowing something that's contrary to your bylaws, you're going to have a lot harder time trying to now restrict something that you were previously allowing. And then my last comment is, how does a landlord evict an Airbnb tenant? And the reason I put this there is because Airbnb tenants do not fall under the standard residential tenancy, the RTA, Residential Tenancy Board. If a short-term renter person decides to stay longer than his lease or her lease, or if there's other breaches of the short-term rental agreement, then the owners actually have to go to court to deal with that, which is a little bit more expensive potentially and a little bit more onerous, I would say, than going through the Residential Tenancy Board. So I think that's it for the majority of my presentation. I think we've got about 15 minutes or so left. Oh, Lauretta, you're muted.
Thank you. Thanks so much, Dionne, Kayla, and Chris. That was some good, invaluable insights. And let's see what questions we have. So one of the first questions there's actually here is, what if you're dealing with old bylaws, for example, bylaws 20 years old, and there's nothing about short-term rentals, and the new bylaws haven't been approved yet. You've discovered a unit is running an Airbnb. If you had a problem, let's just tub overflows, will insurance cover anything? I'll push that to Chris and Kayla.
Sure, I can talk about that if you'd like, Chris. So it won't change anything on your property policy. The policy is going to respond the same way it would if you had the Airbnb or not. So the corporation's still going to respond to the damages that they provide insurance for. That's not going to change anything. So it would just revert back to the old bylaws if you don't have new bylaws, and we would just use that as our guideline on what the corporation's going to respond to in terms of damages. I don't know if you want to add anything, Chris.
I think it makes sense to your explanation. Thank you, Kayla.
One of the other questions, Dionne, this is maybe for you, is that we heard that as of April 1st, a short-term rental is up to 180 days. But how short can a short-term be? Is it 24 hours? Is it a couple hours? Is there any definition there?
I don't think the city has a definition, and I don't know if they necessarily care, because remember, all they're saying is if you have a rental in place that's less than 180 days, we want you to get a license so that you can do it. So long as you have a license to get it, then in theory you can operate that, which may put the condominium back to having to enforce these, I guess, prohibit Airbnbs through its bylaws, especially if you don't need the condo's consent anymore to get your application approved.
So there's a question about that is if you don't need to have the condo board or management company's consent for the corporation anymore, could you put it in your bylaws that that was a requirement? Is there a way around that in order to help these corporations manage this?
Yeah, so I think, I mean, the best thing you can do is enact new bylaws that very specifically prohibit Airbnbs, or say something like they're only permitted upon the corporation's consent, so that the corporation has the same ability to monitor and control them that the municipality does. If you don't have that, or if you're having trouble updating your bylaws, then you're reverting back to the case law and the Cusio cases and reviewing your current bylaws to see if they're strong enough to prohibit Airbnbs presently. So they're certainly not ideal. It would be much better if you had updated bylaws, particularly because of the city change.
So your recommendation out of that is to have a look at your bylaws and make sure they're in compliance with what
Yeah, I would
are.
have a look at your bylaws and consider whether or not you do have anything strong enough to prevent Airbnbs in the future.
So Chris, this question comes from, it looks like an owner that's looking or looking to have a short-term rental in their condominium corporation. Is there short-term rental insurance on the market, and is it easy to get?
Thank you, Lauretta. So in regards to this particular question, I know that definitely a hot topic because there's a lot of Airbnbs, a lot of short-term rentals. The main thing that I could say is there are going to be opportunities to actually get insurance. There are multiple different markets that you can engage. When you're looking at it from the perspective of the unit owner, that would be the unit owner's onus. He or she would have to go out and basically search through either an agent or a broker to basically seek this specific type of coverage. I did actually check in on board because Dionne had made some really good, excuse me, some really good comments when she was talking about the legislation changing. And I did search it myself. You know, when you just go into Google and let your fingers do the walk-in, short-term rental, Airbnb insurance, and Calgary in there, there's a couple of things that definitely pop up. I'm not at liberty to basically tell you, or at least tell the audience which ones that do come up because we're not endorsing any of them specifically, but there are opportunities. One thing that I wanted to do to just really improve a bit upon the response and basically saying that there are options for this kind of insurance that are out there is just really based on the third slide in when we're talking about, you know, more traffic and more opportunities for loss. Because the main thing is that, you know, with scenarios like this, there's always needing to be insurance on all different ends. And in this particular landscape here, you know, it continues to evolve. So, I mean, you know, the bylaws specifically, they should be engaged if the unit owner is looking, you know, to see if they can actually, you know, get the Airbnbs and short-term rentals going, but they should also communicate these items over to the board and their intent. And then just generate a general awareness to make sure that, you know, each area is safe.
So just building off of that, Chris, and this might be another question for Dionne again, is if you live in a condominium corporation that does allow short-term rentals, and thinking of the city's requirements coming in on April 1st, what are some things that the board should put in place to really make it a win-win for everyone? So that you're protecting your insurance, you're protecting the corporation, the other residents that are living there, board members, and then the guests of the Airbnb. What are some things that they could do to make it good for everyone?
I can start off and then Chris can maybe chime in. But for some of the condos that I work with right now who do permit Airbnbs, what I find they've put in place is a pretty substantial Airbnb policy. It's a few pages long, so I can't recite it all. But some of the good things in there are we're not obligated to permit this indefinitely. We may revoke our consent. Now, there's a question about whether or not that will be enforceable, but that's in there. You have to provide us proof of insurance, just like you have to provide the city proof of insurance. You have to provide the condo proof of insurance. And I think some of them I've seen have like a 3 strikes or a 2 strikes and you're out. So if your unit is getting multiple fines, your license can be revoked. So stuff like that is important, I think, just so that the condo retains a little bit of control. Because once you just allow these, it is, like I said, really hard to go back, and you don't want to be in a situation where, I don't know, you're getting a ton of insurance claims and then your premiums are going up as a result.
Chris or Kyla, do
I
you have
think,
anything to add on
I,
that one?
thank you, Lauretta. And thank you, Dionne. You hit the nail on the head. The main thing is to basically ensure that, everybody is well aware, kind of like my last comment. If there is a scenario where there's going to be a unit owner, taking a look to ensure that they can, get an income stream through an Airbnb or short-term rental. Communication is paramount, especially communicating the intent over to the board. It can be one of those things where, it's like the Wild West, right? Like you have a scenario where, people may not know to engage and understand if that's even permitted within the condominium. So, folks need to get in touch with their board of directors to basically understand if this is actually permitted. And if it is, I can't advise, specific protocol because it would overstep my boundaries as an insurance broker. But one of the things I do see, really, resides on the back of some of Dionne's comments. The fact of the matter is that, the corporation can potentially or may potentially define a system to really track to see who comes in and about. Because I mean, the main thing is holding harmless and basically taking care of the corporation's insurance policy, as we were basically saying in the first slide, that it is the first loss respondent. So, I mean, the corporation at that point in time definitely has a vested interest to ensure that they know exactly what goes on, because the main thing is that if there are claims and when they do occur, if the corporation's insurance is first loss respondent, it's definitely going to show towards the loss history if there's frequency and or severity, as we had spoken about. And there could be a scenario where, upon renewal, if there's a lot of claims or any claims activity, small or big, it could actually increase the premiums. So the main thing is basically controls, to Dionne's point, and to basically communicate. So if there is any unit owners, that are thinking about doing that, they have to get in touch with the boards of directors first.
Excellent, thank you. So just a question just came in, just to build on that a little bit. You have a bad situation in a short-term rental, and acknowledging that a lot of those people out that are using short are good people, but you're now dealing with a bad situation and you've got illegal activities. How and who do you reach out to for help?
So I'm guessing this is as a condo board.
As a
They're seeing
condo board.
illegal activity. Yeah. I mean, as a condo board, I would always loop in the owner immediately, if they're unaware. If they are aware of it, then you probably use the sections of the act where you can evict the tenants, just like you can evict other tenants who are not complying with bylaws or who are engaging in illegal activity. That will help you with the current tenants. But if you need to stop the ongoing behavior, you may be looking at taking court action as against the owner.
So, and knowing a lot of this is changing April 1st, so it'll be potentially harder for the boards to know if people aren't disclosing. Where does the city step in from their regulatory and how they've set it up? Is there penalties? Are there legal consequences? Can you foresee? I know the little ball of future thinking is what's the city's role in this?
I think that is a great question. And I don't know. Because we've reported it before to the city, and sometimes, like, I personally haven't seen when they take an action, because they usually do that on the back end with the condo if they've taken action. But anecdotally speaking, I haven't seen them do a lot,
Okay.
which may be why they're asking the platforms now to give a list of the STRs so that they can ban the ones or cross-check the ones that have licenses, so that they are more able to take action.
Okay. And I'm just, a couple of these we've answered in the presentation that came in before. Any advice on conflict resolution techniques or resources for mediation? So as you're working through this, and this is obviously, it looks like it's from a board here that potentially has a challenge, is where do they go for help?
Sure. Like, as I think your lawyers can refer you condos to a mediator if that's what the board so wishes. There are private mediators. I think a couple of them are listed through the Canadian Condominium Institute. And you can even contact the Canadian Condominium Institute for some names if that's the way the board would like to go. If mediation is not successful, then don't forget the board does have a duty to enforce its bylaws. So even though that may be an interim step that it might want to take, it will have to enforce its bylaws eventually if the mediation is unsuccessful.
Okay.
May I just add to this that comment there, Lauretta?
Please.
So just in regards, I did want to kind of take 2 steps back into the initial part of the presentation. So I mean, if there are any, policies that are BFL administered, I can really speak towards, the corporation's policy because I would know it for what it is because we do have a specific product that is only afforded to BFL. But because, largely speaking, some of these questions are in and around, further developments that may develop for the corporation. One resource that they could actually check into, and Kayla may want to add a couple of thoughts if needed, is the AREG legal expense. So the AREG legal expense is the access for the corporation to basically, have legal representation, or they can basically have unlimited legal advice. And to your point, Lauretta, yes, this is definitely quite interesting. And, to Dionne's comments about what's happening in the legal landscape, April 1st is coming around the corner, and we all know that, this is a very interesting topic, for all of those who are vested, unit owners who basically want to engage or have engaged, and condominiums that basically house them, right? So, if there is a scenario, because this is an ever evolving topic, corporations are, at liberty to basically, seek out a bit of legal advice, potentially from, the unlimited legal advice section if they're insured through BFL, managed through, Emerald Property Management, and, maybe just get a couple of cents on there because the main thing is that change happens and change happens super quick, and it's always good to have your finger on the pulse.
Excellent. Well, we are just out of time, so I'll just take a moment to thank you again, Dionne, Kayla, Chris, so much for invaluable insights today. I know I certainly have taken away that awareness is key. Things are changing and will change again on April 1st, and will continue. The landscape as it impacts short-term rentals and condominiums will continue to change. But with that awareness, if we can control the loss for the protection of the corporations, and understanding that first is a great spot to start through legal expertise like Dionne, and then seeing where that impacts the corporation's insurance, because it is a big expense. And that also, this is a really interesting and layered topic with lots of nuances and experiences that come to play. And it really depends on the culture of your corporation as to whether this is a fit or not. So, that's reaching out to your property managers at Emerald. How can we help get that conversation going and connect you with the experts that are out there? So thank you again to the 3 of you, and enjoyed this time. I hope to our participants that you found today helpful and the information useful. We will be following up shortly with a link to today's webinar and some additional resources. And we hope to do this again in the near future. So thanks for attending. Check your email for follow-up, and we'll talk to you again soon. Thank you. Have a great day.
Thank you.